And now on to the final speaker of the day. I have practiced pronouncing this name many times. Professor Zhixiong HUANG from Wuhan University, who is also involved in as one of the experts in reviewing Tallinn Manual 2.0, and who has participated in the center's projects before. And he's going to represent his views, or his amendments, or his critique to the Tallinn Manual as it was published a few years ago. Thank you for joining us, and please, the floor is yours.
Thank you. I would like to thank the organizers for inviting me here to discuss issues relating to the Tallinn Manual with a distinguished group of experts, including Professor Michael Smith, Dr. Busby. Due to the limited time, I don't want to emphasize, in my view, how important the Tallinn Manual is, or how much I respect the work done by Professor Schmidt and other authors of the manual. Please allow me just to say a few words on the purpose of my presentation. Earlier this year, the organizers of the event happened to know that I was drafting kind of review of the Tallinn Manual with some different understandings or different views on certain points. So they asked me whether I can share my views here with the other experts. So this is surely a great honor for me, but it's also a big challenge for me. So my short presentation will be divided into 4 parts. First, it will assess the scale and effects criteria. And secondly, it will discuss whether there is a tendency in the Tallinn Manual to interpret the right to the right to self-defense in an expansive manner. And thirdly, based on the first 2 parts, it will consider whether the Tallinn Manual somehow serves the so-called military paradigm for maintaining cybersecurity. And finally, some implications for the Tallinn 2.0 process. Let's first look at the scale and the effect criteria. I think we all know very well that in contemporary international law on resorting to force, there are 2 key rules. Number 1, as a principle, use of force in international relations is prohibited under Article 2, Paragraph 4 of the UN Charter, and number 2, Article 51 of the UN Charter allows states to exercise the right to self-defense when there is an armed attack by another country. Then, from the perspective of use at Bellum, the core issue, or I would say the single most important issue in relation to cyber warfare is whether a cyber operation may constitute a use of force under Article 2, Paragraph 4, and an armed attack under Article 51. There are a lot of debate on this issue, but it seems that there's no consensus so far. In the Tallinn manual, the authors of the manual provide an answer. Yes, a cyber operation can reach the use of force and armed attack threshold, depending on its scale and effect. So here I'm quoting the two relevant rules in the Tallinn manual. That is Rule 11 and Rule 13. From what I can see, there are several problems with this criteria. First, to what extent can the scale and the effect of a cyber operation be compared to those of a non-cyber or operation or a traditional military operation? Since, as we know, traditional military operations normally involves human injury and physical damage. Well, this is not the case for the vast majority of cyber operations. You can have many examples. Can a cyber attack against the the network of the New York Stock Exchange, which caused substantial financial instability, constitute a use of force? We can have different answers, but my point is all those answers cannot be based on an objective comparison between the scale and the effect of that cyber attack and those of a military attack. In order to remedy this problem, the Tallinn manual adopted the famous Smith analysis, which involves an assessment of a series of factors, including the severity, immediacy, directness, etc. It seems that these factors provide a more reliable basis for the comparison. But many scholars also disagree with this analysis. So, for example, Professor Schmidt, in one of his earlier papers, applied those factors to discuss whether the 2007 cyber attack against Estonia constitute a use of force. But for for some scholars, including from myself, that attack is surely to be condemned. But how can we determine it is a use of force based on these factors? And it has been argued, and I quote here, that according to at least one author, these factors can be too easily manipulated to create results supporting the geostrategic goals of the nation conducting the inquiry. So that means applying the same factors can easily come to a totally different conclusion that that attack in 2007 is not a use of force. And also, I'm quoting the findings of another scholar. The examination of those factors suggests that virtually any event of computer network attacks can be argued to fall on the armed force side of the line. So in short, the point for me is, even with these factors, a comparison between the scale and the effect of a cyber operation and those of a non-cyber or military operation is still a very subjective and arbitrary process, I would say. The second point, supporters of the scale and the effect criterion tend to argue that at least hypothetically, certain cyber operations, like a cyber attack on the computer system of an airport, which caused the destroy of an airplane, will result in the scale and the effect which are highly comparable to traditional military operations. But for me, this had to do with the second potential problem of the criteria. For me, a consequence with the same scale and the effect can be caused either by a forceful measure or by a non-forceful measure. In other words, a measure with the same scale and effect can be a forceful one or non-forceful one. So here I also try to give two examples. First, an economic sanction by one state against another state may cause huge number of deaths and economic instability, which is similar to the scale and the effect of a military operation. Is that military sanction a use of force? Second example. If an upstream state, either intentionally or unintentionally, leaves some dangerous chemicals in the river and which caused widespread human injury and physical damages to a downstream state. Is that a use of force or not? My view is, depending on the situation, very likely, depending on the situation, the act mentioned in these two examples might be legal or illegal, depending on the situation. But normally, in both examples, they will not be regarded as use of force, even they are illegal. The reason is, in practice, determination of whether an act constitutes a use of force or an armed attack involves a comprehensive assessment of the instrument used, the objective or the purpose of the act, as well as the consequences of the act. So that means the scale and the effect of an act is only part of the story. An important feature in the Tallinn manual is, as also mentioned by Dr. Boothby, the Tallinn manual claimed that the rules proposed in the manual are lex lata rather than lex ferenda. And this brings me to the sad point. For me, it's one thing to say what should be the law, and it's quite another thing to say what is really the law, what is the existing law. The scale and the effect, as was mentioned in the Tallinn manual, was first used by the International Court of Justice in the Nicaragua case. And then the authors of the Tallinn manual adopted this criterion in determining whether a cyber operation constitutes a use of force or whether it constitutes an armed attack. However, in the Nicaragua case, the International Court of Justice stated that in determining whether a military measure, a military operation constitutes a use of force or armed attack should be based on the scale and the effect. It's about military measures. But the Tallinn manual did not explain why this scale and effect criterion also applied to a non-military measure. And it did not provide any evidence on how state practice really support the scale and effect criteria as applied to cyber operations. At what I can see, there's few, if any, state practice which clearly support the scale and effect criteria in relation to a cyber operation. On the contrary, we can find a lot of state practice, including this statement by the Chinese government and some other government which showed their reservation to such a approach. So the third part is whether the Tallinn value tend to interpret the right to self-defense in an expensive manner. And here I will analyze, briefly analyze two examples. Whether it's the first one is the Tallinn value support a right to self-defense against cyber operations by non-state actors, such as rebel groups or private companies, etc. Secondly, the manual also supports a right of self-defense against not a real attack, but rather an imminent cyber operation. I understand that the scope of the right to self-defense under Article 51 is a very complicated issue, both in the theory and the practice of international law. But in relation to the first point, some scholars tend to argue that at least after the 9/11 attack, characterizing, using the right to self-defense against a terrorist group has been established. But for me, this is, in relation to that specific event, I believe this is the case. But the point is that 9/11 a precedent, or rather an exception? This is still a controversial point, and I can this point can be find support in the writings of some influential authors. As to the second point, that is the right to self-defense against an imminent attack. For sure, there are scholars who support, and there are also countries who support such a right against an imminent attack. But from what I can see, maybe to date, most commentators still believe that it cannot and should not be supported by either treaty law or customary international law. For example, according to Professor Jane Claps, that right will give powerful state an almost unlimited license to use force. So, looking at the practice, the record of state practice within the UN also reflect a widespread perception that widening the scope of self-defense will erode the basic rule against unilateral resort to force. So, all in all, I believe that whether there is a right to self-defense against non-state actors, and whether there is a right against an imminent attack, has not been established in international law. It's still controversial. So at least from the perspective of existing international law, we still cannot find sufficient support. And sadly, I will discuss whether the Tallinn value somehow serves the so-called military paradigm for maintaining cybersecurity. So this relying on military measures, the use of force, rules on use of force, rules of use in battle have triggered a lot of debate. What is the military paradigm? So according to Professor Mary O'Connell, this is about the militarization of cybersecurity policies of certain countries. For example, in the 2011 international strategy for cyberspace of the United States, it has been stated that the U.S., when warranted, will respond to hostile acts in cyberspace with military measures. So I think it's no secret that the Tallinn malware has already been criticized as serving a legal justification for that military paradigm. And I fully understand that as a principle, the Tallinn value is the proper product of a group of independent experts acting solely in their personal capacity. And Professor Schmidt also emphasized that this product is produced by lawyers as lawyers. I agree. But then, given its focus on military aspect of cybersecurity, as well as the tendency to interpret Article 2, Paragraph 4 and Article 51 of UN Charter in expensive manner, then I think that doubt for the Tallinn value will continue. Finally, I try to provide some suggestions or to summarize some implications of my presentation, my discussion for the Tallinn 2.0 process. The first implication for me is that rules in the real world might not be applicable in cyberspace. As we all know, after 2013, an international consensus regarding the application of international law in cyberspace has emerged. And I have no problem with that consensus. It should be welcomed. But then the point is, what should be the international rules which is applicable in cyberspace? More specifically, does this mean existing international rules, or it might also cover new rules, new international rules, like new rules specifically designed for cyberspace, like the Budapest Convention on Cyber Crimes. Given all the unique characteristics of the cyberspace, then my quick point is, based on the example of the scale and effect criterion, the application of existing international rules cannot be taken for granted. Or, I agree, many existing rules are applicable, but this should be the application of existing international rules, of all international rules, should not be taken for granted. And state practice should be the key element in deciding whether we need to apply existing rules or we need to have a different rule for the cyberspace. And in this regard, I think it's a welcome movement when I noticed that last month, the authors of the new Tallinn manual held a consultative meeting with a group of at least 30 governmental delegates. I think it's the authors are trying to look more at state practice. The second implication for me is a more inclusive process a more inclusive process will make the Tallinn 2.0 more fruitful. Without doubt, the authors of the Tallinn manual are a group of eminent scholars, but in some part of the non-Western world, this group is also viewed as more like a Western group of experts. And the military background of most of those experts makes their answer to whether use at Bellum, whether use in Bellum is applicable to cyber operation more easier. And now I'm also glad to see that the Tallinn 2.0 is also trying to make the process more inclusive and more international. The last point, it's desirable to shift the focus from the military program to below the threshold regime. My point is that cyber threat is a real threat which should be taken seriously. But it seems that in the recent years, there's been too many talks on use of force and self-defense, etc. So, but in reality, cyber operations reaching the threshold of use of force and armed attack are rather exceptional. So, is it really desirable to rely too much on the military approach? Or should we have cyber security without cyber war in the words of Professor Mary O'Connell? My personal answer to the last question is surely yes. So that's why I welcome the launch of the Tallinn 2.0 project. With this, I finish my presentation. Thank you very much for your attention.
Thank you very much, Professor Huang. I know we are a bit over time, but I'm sure you have some questions.
I'm Chipa from South Korea. You said we can exercise the right of self-defense against non-state actors. Then who can be the target? I mean, state where the non-state actors are situated, or then what if we can? I mean, what if the non-state actors are not situated just in one country? I want your opinion.
Do you mean who can be the subject of the right to self-defense?
Yeah.
In response to
Who can be the target of
the target
of usual force? Usual force
by the attacked state.
Yeah.
My understanding, legally speaking, under Article 51 of the UN Charter, states, an aggressor state who launched the armed attack will be the subject of the counterattack.
Right. Do we have one more question? Right. Last question, Kubo, and then we will wrap up. Over there. Kubo, raise your hand, please. Then you're, yeah.
Again, thank you very much for your speech. I found it really fascinating, and it's very important, I think, to give air also to the criticism of the Tallinn Manual, however an important contribution it is. As Mike knows, I have done a little bit of that myself in the past. But today, yes, I know I'm in trouble already, but today you'll be happy, Mike, I'm going to take your side. I think there is something that we should perhaps defend the Tallinn Manual on, and I would relate to the, your mentioning of the anticipatory self-defense, and you referred to Jan Klaber's in order to support your argument that recognizing this criterion of imminence would, if I can cite, give powerful states an almost unlimited license to use force, is what you said. And you said that this reflects a consensus of the experts. Now, in reference to Jan Klaber's book, now I'm familiar with the book because at Exeter we prescribe it to our students and we teach from it. Yeah. And actually what's important to say is that he distinguishes between anticipatory self-defense to the extent that it is recognized by Daniel Webster in the Caroline case, and he acknowledges that that's a potential acceptable interpretation of the law of self-defense, and he distinguishes that to preemptive self-defense as a more loose concept, and it is only that more loose concept that is indicated to give powerful states an almost unlimited use of force. So perhaps that's something that you should make more precise in your criticism of the manual.
Thank you for your very helpful clarification on what I have quoted from Professor Jane Claps. I have 2 points. One, I'm not saying this is the consensus in the academia circle. Rather, I said, it seems to me that most or more scholars do not fully agree with right to self-defense either to an imminent or preemptive attack. I'm not saying this is a consensus, but it seems that most scholars, if you read the treatise by Professor Brownie and the new revised edition by Professor Corford, thank you, they have serious reservations on this issue. But on your specific clarification, I will have to go back to the book. Thank you.
Thank you very much for the audience for these great questions. Before I'll give our beautiful mark to Professor Huang, final remark, if you have more comments on Tallinn Manual, even more than were presented today, please don't be shy, share these with us. Please send them to Liis Vihul, who's sitting here in the front row, who is the project manager for Tallinn Manual 2. All of your comments are very, very much welcome. With that, again, an applause for Professor Huang. Thank you for everybody for being here.